Hi everyone and welcome back to this week's episode of Digital Law News. I'm joined today with my colleague Peter Wright and I'm Laura Spencer, an apprentice solicitor at Digital Law UK. So for those who don't know, Digital Law is a niche law firm based in the UK and we specialise in all things to do with data protection, technology and other data online data matters. So I'll just pass over to Peter to introduce himself and then we'll get started with today's stories.
Thank you, Laura. I'm a solicitor and managing director at Digital Law, and we're sort of back from our summer holidays now. And it turns out that while we were away, it's not as though nothing happened. It's been quite quiet, really. Just the largest GDPR fine to date for Amazon, multi-million-pound fines for WhatsApp, and the UK decides it wants to go in a different direction when it comes to data protection regulation. So nothing major at all to cover, really. I think it should be a really quick episode today as a result.
Thanks, Peter. Right, so starting with the first story. So this is one that's been talked about over the last couple of weeks, and this is the Digital Department for Digital Culture, Media and Sports plans to change the UK GDPR, as they call it, so the Data Protection Act 2018, and to kind of update that to after now we have left the EU. So this has obviously come from the Department for Digital Culture, Media and Sport, as I've just said, and they're now embarking on a major consultation centering on proposed changes to the UK's data protection regime, along with other reforms to the ICO as well. So these proposed changes actually include reforms to the DPOs, the end of mandatory DPIAs, which is data protection impact assessment, and changes when it comes to reporting breaches as well. So I think this is all surrounded by a lot of talk that the current regime actually places disproportionate burdens on some organisations, obviously small businesses and large businesses, multi-million-pound enterprises still have the same requirements. So they're wanting to move towards a more common sense approach rather than a tick box exercise.
Indeed, thank you, Laura. And this is an interesting story because I think there is a section within the government, certainly a section within Parliament, that have always viewed GDPR as one of these things that once the UK was out of the European Union, they could, in speech marks, scrap GDPR. And you think, well, that's bit of a radical step. That the UK was a leader in data protection law. We had data protection laws in the UK before they came in Europe. Yet the idea of just wholesale abandoning it and moving to sort of the Wild West has always seemed a little extreme. What's being proposed here isn't the full-on scrapping of it, more a reform. And on paper, a lot of it sounds quite sensible, saying, reforms to the requirement for a data protection officer, end to mandatory data protection impact assessments. It seems sensible until you then look at the fact that under the existing GDPR, you don't have to have a data protection officer in all organizations. You really have to make a value choice. And Laura, you and I were talking to one of our clients earlier today and trying to argue that in effect, we didn't really think they needed to have a data protection officer. They have a commercial website, they're a trade supplier. They've got turning over quite a large amount of money, but looking at it, we tried to look and think, are we looking at either a small volume of highly sensitive data? And the answer was no. Are we looking at a high volume of data? And I can think of, lots of sort of digital tech startups with apps and innovation that could be handling much larger volumes of data, user data and sensitive data compared to what our client here was using. And I looked at it and thought they probably don't really need to have a DPO. And this isn't an SME. I'd say it was a sort of regional medium-sized enterprise. So there's no hard and fast rule that says you have to have a DPO in the current law. And it's not necessarily mandatory DPIA now. It's just, you should have a DPIA if you're embarking on a new project or exercise, like say a new app or a new website or a new venture. And we've worked with a lot of clients on that, but we're always anxious to say, look, if you can't pay for this to happen, then use some of the free tools like Canil's free DPIA tool. So at least you're doing something. And we're always saying to our clients, look, if you simply don't have the money and the resources right now, look at this, do something, make sure you've got a DPIA on file, and when you're a little bit further down track, then we can help you, check the results and do something a little bit more thorough for you. But this sort of perception that GDPR is about nothing more than restrictions and tick boxing, I think is a little bit of a misnomer, and therefore to suggest, oh, let's just bin the whole lot and get rid of the extraneous bits, I think suggests that these suggestions made by people who don't necessarily understand what the actual text itself says. You've got to read the Act, you've got to look at the recitals, you've got to have worked with organisations and worked out what practical compliance looks at before you really start coming up with these proposals. Yeah,
absolutely. Like some of the changes, like you said, they're not changes. The changes that they're proposing are not changes that would be kind of have much effect. Like you said, nothing that they're suggesting that is mandatory. It's kind of like a weigh up scenario where you've got to weigh up the risk. But yeah, it'd be interesting to see when these changes come into force and what actual changes substand the consultation period.
Exactly, and it's going to be, I think some of those who think there's going to be widespread sweeping change here are going to be sadly disappointed with what they get, which is probably just going to be a little bit of tweaking at the edges. And of course, one reason why the UK can't carry out massive wholesale reform here is that long-running saga over adequacy that we were talking about earlier this year. We have the UK's data adequacy decision from the European Commission. The UK had to pass through the eye of the needle to get that decision to allow the personal data of EU citizens to freely flow to the UK. And if you started putting a line through vast tracts of GDPR, that adequacy decision will probably fall. And so far, there hasn't been a massive effect digitally on the digital economy from Brexit. Well, look, we've seen some of the potential impacts when it comes to imports, exports, whether they are real or perceived is a conversation for another podcast, not ours. But certainly from a digital perspective, there hasn't been too much in the way of sort of pain from this so far. But if there wasn't adequacy, then you'd have a problem. So I think that the room for manoeuvre here for the UK government is not great. And I think, as I say, a lot of campaigners who think, oh, there's going to be massive change here are going to be disappointed with what eventually is sort of comes out from the Whitehall legislative sausage machine, as it were.
Yeah, absolutely. So moving on to our next story today then. This is in relation to the Amazon fine that has been recently imposed. So this, I believe, was imposed probably last month now, but more on this has been coming out over the last couple of weeks. So this is a £636 million GDPR fine on Amazon. And this is the first significant GDPR ruling against a big tech firm. And why this seems most important is because it's one of the biggest fines, well, it is the biggest fine under GDPR against one of the tech firms. And it's actually almost double of all the fines given out under GDPR, basically all added together. So that's why it's such a big thing here. So this fine was imposed by Luxembourg against Amazon, and basically under GDPR. So I'll just pass over to you, Pete, to give some more information about it.
Yes, thank you, Laura. This is a fascinating fine. I mean, I think, first of all, any listeners who've thought, 636 million, that sounds a lot. Is it really 636 million pounds, or is that euro? The answer is it's 746 million euro, which is 636 million pounds. So we're looking at the largest fine to date by a very significant margin.
Yeah.
We can't actually tell you the nuts and bolts in terms of what they've been fined for, because this has been a fine handed down from the Luxembourg data protection regulator, and they have quite a complex professional secrecy law in Luxembourg, which means they can't actually publish any details of why the fine has been applied until the appeal process has been completed. And Amazon have said, of course, they want to appeal the fine. Who wouldn't want to appeal a fine of almost €1 billion if you thought you had good grounds to at least possibly even just get it reduced rather than get it totally thrown out. You'd want to go through that appeals process, and as we know, appeals processes can take a long time, and appeals processes can take even longer during times of a global pandemic, as we have found over the course of the last 18 months. So it looks like there hasn't been a specific data protection breach here. What we're looking at is a fine levied because of Amazon's practices in terms of how it collects data. And we all know that Amazon collects huge amounts of personal data. Let's actually look at the scope of that. You've got all the data from the people who buy things through Amazon. You've got all of the data potentially associated with now the fact that Amazon stores huge amounts of data in the cloud. So we aren't talking about personal data that companies are storing in there, but all the data related to all of those companies and all of those customers is certainly personal data. Then you have all of the data collected by Amazon's home listening project, otherwise known as the Amazon Echo, which listens to all of your conversations. Yeah, the Echo isn't just listening for when you say, Alexa, and to all of those of you listening, if I've just triggered your Amazon Echo by saying that word, apologies, but I needed to say it. If you say the word Alexa and it starts processing, Alexa, stop. There you go. The thing is always listening. That's the problem. So therefore, you have to be very careful how you potentially use those things, and making sure that they are only used in very certain circumstances. And for example, I have an Echo there. I switch it off when I'm on client confidential calls, as you can imagine. But the point is that they are collecting huge volumes of personal data. And clearly, Luxembourg here have turned around and said, we are not happy with your processes and the security measures and whatever else you may have in place around how you collect that data. And they've probably got issues with regards to transparency. But this is all hypothetical. We don't know the nuts and bolts of exactly how and why the fine has been applied. So this will be something that we'll learn in due course. That will probably take, to be honest, maybe even another year until we find out exactly what the reasons for the fine were, if indeed the fine is upheld. But I would hope that the Luxembourg data protection regulator was clear in why they wanted to apply this fine. I'm sure they will have liaised with their colleagues through the European Data Protection Board, made up of the other European data protection regulators, before applying this massive fine.
Yeah.
And we'll just have to see if it is upheld, and then exactly what was the cause of the fine. But it looks like it's probably been Amazon's practices have probably never really complied with the view in Luxembourg of how GDPR should be applied. But also, I think it's worth flagging up that GDPR, even despite it being a regulation and you're thinking, oh, this applies across the entirety of Europe from May 2018, it applies across Europe in different ways, as we've talked about a lot before on this podcast. So the type of GDPR you get in Germany, it will vary in Germany. If you're in Bavaria or Schleswig-Holstein, there are different versions of GDPR applied at a state level, which is different from the version of GDPR you get in France, which is different from the version of GDPR that you get in Spain. So the point is that there is this variation in the standards in terms of how GDPR, what is in it, and there are variations in terms of how it is enforced. So I think the big takeaway from this is, look, we always thought we'd get big fines under GDPR. Here is one. Let's see if there are more big fines, and let's see if this one is upheld. So watch this space.
Yeah, absolutely. Just referring to the how long the appeal process can go on as well. Well, we only have to think back to BA and Marriott, how long that process went on to get an actual decision there. Hopefully it's not as bad, because obviously that industry was affected a lot. So I'm guessing that wasn't a priority to anyone. But yeah, it could take a very long time to get this through.
Exactly. I think those fines were first announced in 2019 when you and I were at a conference in Poland. And I think we were well into the pandemic when those fines were eventually upheld after the appeal process, but of course they were heavily reduced because, funnily enough, airlines and hotels haven't done very well in the pandemic, so they could say, oh, you can't apply hundreds of millions of pounds in fines to us because we might have to make loads of people redundant. So funnily enough, the amount was reduced, though Amazon, of course, has done incredibly well during the pandemic, so they have very deep pockets. I'm sure that didn't come into the thinking of the regulators at all, but yes, as I say, could be a long time until we actually hear the detail on this.
Yeah, absolutely. So sticking with fines then, so this is a fine by the Irish data protection regulator, and they have fined WhatsApp €225 million for breaching EU privacy rules. So Facebook's WhatsApp has actually been fined €225 million, like I said, by the data protection regulator in Ireland. After the EU privacy watchdog actually pressured Ireland into raising the penalty for the company's privacy breaches. So the issues leading to the fine related to whether WhatsApp conformed in 2018 with EU data privacy rules surrounding transparency, which includes information provided to data subjects about the processing of information between Facebook and WhatsApp as well. WhatsApp have come back on this and said they are appealing, like most do, as they said that the fine is entirely disproportionate.
Indeed. So there's a lot of information to unpack there. The first point, as you quite rightly made there, Laura, is WhatsApp is Facebook. It is surprising how many people don't know that WhatsApp is owned by Facebook, and increasingly is being more closely integrated into the Facebook into Facebook. So indeed, there is a increasingly greater level of data sharing between WhatsApp and Facebook. And the key thing here is it looks like there is a lack of transparency. So the Irish Data Protection Regulator said that there was a very significant information deficit in terms of the information given to users of WhatsApp. And indeed, it was felt that where WhatsApp had only given 41% of the prescribed information to registered users and none to non-registered users. So hence they felt there was a deficit, hence they feel that not enough information is given out to users when they subscribe to and start using it. And they felt that this breached the general core principles of GDPR around lawfulness, fairness and transparency, which are at GDPR's core, as well as some of the requirements to, for example, communicate with data subjects about their data processing rights. We at Digital Law spend an awful lot of time drafting what we think are privacy policies that are written in clear, plain English that articulate both how a organization handles data and also articulate the data subject's rights in nice, clear, plain language. And in this instance, they're basically saying that there is simply not enough data provided by WhatsApp to its users, and that's through a mixture of not giving good enough transparency at that sign-on process and simply then not regularly advising and updating on changes to that. So it's really going to be, again, a matter of seeing what comes out in the appeal process. We know a bit more about the fact that, yes, the Irish Data Protection Commissioner has confirmed the reasons for this fine, which is structural, the infrastructure within WhatsApp and how it handles data simply not complying with GDPR's principles. Though now we'll have to see if they really do stick to their guns. And it looks like the Irish Commissioner was almost sort of pushed towards applying this fine by the European Data Protection Board, which we talked about earlier. And I think it's really important for enforcement of GDPR as a whole that this fine sticks. If it is reduced, if it is watered down, it is then, I think, a major victory for the tech firms to say, look, it turns out that we have been able to use our sort of equality of arms, you know, all of our expensive lawyers and resources to actually beat back the big stick of enforcement here from the regulator. So I think it's actually a really important moment for the enforcement of GDPR when you look at this fine for WhatsApp, when you look at that fine for Amazon. This is the point where we find out if GDPR really does have the teeth that we've been saying it has all the way since 2018. So this is it now. This is the acid test. I mean, the average organisation out there shouldn't be worried about that it's going to get a fine through the post of hundreds of millions of euros for the fact that their privacy policy wasn't up to date. But it does, if you get big fines for WhatsApp and Amazon and they stick, then that's saying to everyone else, look, we are actively enforcing this. You do have to comply with it, and proportionate enforcement could be applied to any organisation. So you wouldn't necessarily get hundreds of millions, but you could still get a sizable fine in terms of thousands or tens of thousands or hundreds of thousands of euro, and that's something that all businesses across the European Economic Area need to be considering when they are investing in and using technology as a result.
Yeah, absolutely. Like you said, these fines, the WhatsApp Ireland one and the one by Luxembourg against Amazon, kind of show the potential power of GDPR, but this power hasn't been exercised up until now. We've not had the big fines. The biggest one was probably, I can't remember who it was, but probably BA or someone.
Indeed, BA was the largest one in the UK, and then France fined Google 50 million way back in 2018, just for generally failing to adhere to GDPR's principles. But I think the key bit is that bit you mentioned earlier on, Laura, when we're talking about Amazon, and the fact that when it comes to all of those GDPR fines applied to date, you could double them and you still wouldn't be reaching the value of the Amazon fine that's been levied now. So there really hasn't been either the size of the fines or the volume of fines in terms of enforcement that I think we would have expected in 2018. And I've heard a lot of people writing off GDPR and saying, oh, it's not being effectively enforced, so people are ignoring it. And that's why applying these big fines, almost nailing Amazon and WhatsApp to the wall as an example to the rest, is so very important. And if this fails, I think GDPR is in significant difficulty. Therefore, I hope that these targets have been very carefully identified, and that there is no wriggle room for them potentially to wriggle out. Because if there is, an awful lot of businesses will look and say, well, why should we spend our resources complying with this when you aren't actually able to apply effective enforcement?
Yeah, absolutely. So moving on to our next story then. So this is a blog that was published by the ICO, and this is a blog that is targeted towards universities and colleges, as students are obviously going back to university and college, and it's regarding the sharing of personal data in like an emergency situation. However, it is kind of relevant to a lot of businesses, either businesses starting up or just business in general, of just little things you should be doing to make sure that you are lawfully sharing people's personal data and safely doing it as well. So the ICO have basically set out some practical steps. So basically, number one, planning ahead, carrying out a DPIA if necessary, or just putting plans in place as to how you're going to share the data, what happens if anything goes wrong, etc. Having a data sharing agreement in place with those who you're sharing data with, making sure staff are trained on data sharing and data protection in general, and also having access to the ICO's data sharing resources, in particular their data sharing code of practice as well, which can be found on their website.
Thanks, Laura. This is a really interesting piece of information, and you can't help but think that it is, of course, highly relevant for where we are in 2021 as students do indeed go back to university campuses. Because it says it's like the sharing of data by universities and colleges in an emergency. And I think we can see what emergency they're thinking of. They're thinking of the emergency whereby, vast numbers of COVID cases could be identified and halls of residence being locked down, or universities being closed and students having to travel. Because we're talking here about, the testing is something that many organisations and employers have had to wrestle with over the course of the last year. Many of our clients have actually got boxes full of COVID tests, lateral flow tests, that they've been using to allow their staff to end up getting tests regularly and then look at them. And of course, if the lateral flow then suggests you have got COVID, you can then go and get your PCR test from a lab to confirm any potential diagnosis. And of course, during the summer, what's happened? Well, we've come out from restrictions and cases have risen. And it is envisaged that universities may, as they go back, you could end up with significant clusters of COVID cases as a result. So we could have large volumes of personal data, very sensitive personal data in terms of people's names, addresses, contact information, and whether they've caught this terrible disease. So the ICO here is trying to say, plan ahead, carry out a DPIA. Are you looking after that data in the safest way possible? You know, no one wants to find paper spreadsheets or a spreadsheet being shared on Google Docs with the wrong person that leads to a data protection breach. So the ICO is trying to be proactive here and saying, think about how you're going to be sharing this data in advance. So it is a really important principle. They're also talking about that most important of things, training. They're making sure that everyone who's handling this, you know, if you've got lecturers suddenly being asked to handle volumes of information on this, make sure they know what they should be doing with it. So really important guidance and really important that it gets out there.
Yeah, absolutely. So moving on to our next story for today then. So this is in regards to the Apple patch they've recently patched a security flaw that leaves users vulnerable to spyware. So Apple have issued an emergency software update after the cybersecurity researchers sorry, that's the company that they're talking about, have said that they have covered a new vulnerability allowing hackers to deploy Israel company NSO Group's spyware tools through the iMessage functionality. So this could be done using a MacBook, a iPad, anything with the iMessage system on there. And it could be done also without the use of the user needing to actually click on a malicious link or click on absolute anything, which is known as a zero-click attack. So the report also added that the military spyware manufacturer NSO has been able to use this vulnerability remotely to exploit and infect the latest Apple devices with its spyware since at least February of this year.
Thanks, Laura. That's a really detailed update. And all I'd like to add to that is just say that awful lot of people out there who are Apple users that I speak to say, oh, I don't have to worry about cybersecurity because I'm an Apple user. Well, this shows that if whatever your device you're on, Apple, Android, Microsoft, Google, it really doesn't matter. You're going to be vulnerable to being exploited. And in this instance, some quite sophisticated spyware that can infiltrate the iMessage app and get into the Apple's devices. So it doesn't matter whose device you're using, you can be at risk. Make sure that you are always updating the device. You know, Apple have issued the patches that will hopefully reduce this vulnerability, but that will only take effect if you're allowing your device to properly update. So, you know, sometimes people don't like to switch off their iPads and phones very much because they're always using them, but it is important to regularly switch off devices, switch them back on, allow them to update, allow them to schedule their updates, and make sure these vulnerabilities are closed down. But an illustration that there are no safe platforms out there, everyone is at risk.
Yeah, absolutely. And I think it's quite interesting how all these patches are always, need for the patches are always found by researchers and never by the actual company.
Exactly. It's were it not for the white hat hackers out there who are identifying these things, it would be you'd be at the mercy of, you would only find out until a few thousand people have been hacked, and then Apple works out what the problem is. Yeah,
absolutely. So moving on to the last story today then. So this is regarding some actual research that's been carried out by a company called Manage Engine. So the title of the story is less than half of the UK organisations have adapted cybersecurity processes to match changes in remote working. So the majority of those surveyed are UK organisations and IT professionals in particular. And the majority of those surveys are relying on employee education rather than wider statutory changes to actually meet the challenges of today's remote working scenarios. So according to Manage Engine, who carried out the research, 67% of organisations raised employee awareness around security threats, and 66% of those have provided additional training on cybersecurity. I think some of the most interesting statistics is that less than half of those surveyed in the UK were involved. They actually didn't adapt their organisation security strategy. They only kind of trained people more. They didn't actually change the way they operated or anything like that. All they relied on was the training they provided their employees. And some more interesting statistics as well is that 45% of these saw a rise in phishing. 38% of these saw an increase in account hijacking. 36% saw an increase in social media-based attacks. So that could be phishing as well. And 34% of them actually saw an increase in endpoint network attacks. So I'm guessing that's to do with through networks they're using. It could be even Wi-Fi and things like that as well, with not adapting home Wi-Fi to kind of adapt for the new home working from home changes.
Indeed. I find this a really worrying survey because we've been talking, with our clients around the risks of having staff working from home for extended periods, and to talk about the fact that you need to make sure this is being done in a safe and secure manner. And I know an awful lot of organisations had no choice but to establish home working at speed back in March and April of last year. But we've been doing this for 18 months now, and restrictions have been lifted as of July. So if you're going to continue having staff working from home, you need to actually take this seriously and make sure that you are putting in place reasonable, good, secure systems to allow for this, and also potentially even carrying out a mini assessment of the employee's home working environment. What devices are they using to get online at home? Have they been given business devices? Are they using their own devices and laptops and desktops? Are they on their home Wi-Fi? Is that home Wi-Fi shared with other devices, like anything from your Amazon Echo to your fridge freezer that could be an IoT device, or CCTV, or if you've got one of those Ring alarms? All these sorts of things can all be run through the home broadband, and sometimes home broadband is not particularly secure depending on your provider. It also depends if you have lots of people coming and going from your home address, and particularly if you've got teenagers, adult children who are always inviting over friends, sharing the Wi-Fi codes. It can mean that systems are vulnerable. So make sure that staff, have you got a VPN in place that they can use, that they have to go in and log into before they start going onto business related systems? Is it worth giving them business devices and saying you just use this for your work and nothing else? There are loads of measures that can be carried out to minimize risk. And also, those stats that you read out there, Laura, 36% has seen an increase in social media based attacks. So do staff know, for example, not to start back and forth exchanges with people they think might be customers or potential customers via, say, LinkedIn? To say, look, don't use the instant messaging on LinkedIn for business related activity. If someone contacts you, get them onto your business related email, which benefits from a spam filter and antivirus measures. Because if you're just doing a back and forth on LinkedIn Messenger, or someone sends a dodgy link and you click on it, that can still put ransomware onto your system. And it's these risks that just aren't being properly articulated to staff, and the right security measures aren't being put in place. I entirely get the fact that this was not possible to do all this back in March of April last year, but we've been here now for more than a year. Global pandemics, I hate to say it, are usually defined as lasting for at least 5 years. So there's going to be a while of this to go, vaccination or no vaccination, until we get to a point where I think absolutely everything is absolutely safe and we can return to working exactly as we were. So as well as the government sort of saying to people, be careful and wear masks and be careful, take certain measures. businesses need to be taking measures to protect their data when their staff are working from home for extended periods. And this is something that now the pandemic becomes less of an effective excuse. You can't say, oh, we weren't able to because COVID. Now you've got to say, well, actually, you've had time now where you should have put something in place. So if you don't want your organization to be one of these stats, now think about putting a plan in place.
Yeah, absolutely. I think we always say that one of the biggest things is training. So it's good to see that a lot of, like 66% of companies have provided extra training and raised awareness of employee about security threats. But if you don't have the resources in place as well as the training, it kind of makes the training less effective.
Exactly. I mean, when we're delivering training actually to our clients on cybersecurity, we always talk about sort of having a cybersecurity triad, the 3 things you need to have in place to provide effective defense. And security measures are one of those things. The second is the training, and the third is having adequate insurance in place. And if you've not got all of those 3, you have a weakness that will be exploited. So it's all well and good having the training, like you say, congratulations to those who have done it. But if you've not put good security measures in place and you've not got a good breach response plan in place, you're still, running a significant risk. And it's important to now sort of start holistically looking at this and getting plans in place and actually trying to make sure that you are minimizing your organization's overall risk outlook in relation to the ongoing cybersecurity risk that you're running by having large volumes of staff working from home. Yeah,
exactly. So that was the last of today's stories. So that's everything for today that we're going to cover. We just want to say thank you once again to Anson Evaluate for helping us produce this. Also, Anson Evaluate do provide a lot of guidance on some of the things that we've actually discussed today in regards to training, in regards to phishing. There's a lot of blogs on their website that provide a lot of useful information about that as well. So if that is something you're interested in, do feel free to go ahead to their website or drop them an email if you want some individual training provided or anything like that.
Indeed, and also do keep an eye on Anson Evaluate there'll be a series of webinars coming up between now and the end of the year that will help you when it comes to minimizing some of the risks that we've talked about today when it comes to things like anything from data protection breaches to social media exploitation and others. So again, plenty of reasons to go along and take a look at the Anson Evaluate website.
Great. So thank you once again to everyone for listening today, and we should be back next week with another episode. But in the meantime, there is plenty of episodes to go look back at if you are interested. And again, lots of resources on both our website and the Anson Evaluate one as well. So thank you for listening, and we'll see you again next week.